Hello, friends. In preparing for Michigan real estate continuing education courses, we often run into some interesting court cases that can benefit the real estate agent in his or her practice, as well as any investor, landlord, tenant, anyone involved in real estate. And the following case will be an interesting one. What's so special about this case is you may place a condition in a contract to benefit buyer or seller, landlord or tenant, but because of the language, sometimes one word makes the difference. The contract or the clause will backfire and it will hurt you instead of benefit you. And the following case is a good example. This case involves a lease that has three 5-year options, renewal options. Those options will renew automatically. There is no need for the tenant to do anything. There are two conditions. The tenant, if he does not want this 5-year to renew every time, must notify the landlord 6 months or more in advance that he's moving out. Number two, the tenant cannot be in default. What happened there? The tenant fell in default. The landlord notified him. It's undisputed in court that the tenant was in fact in default at one time. So when the lease expired, the landlord noticed that the tenant moved out, contacted the tenant and said, "You're supposed to let me know you're moving out at least 6 months or more in advance that you don't wish to renew. These renewal options renew automatically. So you got yourself another 5-year lease. You owe me the money." And the tenant said, "Not if I'm in default." "Didn't you tell me I was in default?" "True." "Well, then how did the automatic renewal trigger?" "It did not trigger. This was an option, and I decided not to take advantage of it. And I have no right to take advantage of it." That's what the trial court said, and that's what the Court of Appeals said. They said, "You told him if you're in default, there is no automatic renewal. Apparently, later on, you decided that you really wanted him to stay. It's another 5-year lease." Well, unfortunately, the way you structured this clause in this contract is that if the tenant is in default, the tenant is denied the right to ask for that 5-year renewal option. So if he couldn't ask for the renewal option, how can you say he's in default? You follow me? So that's what they said. That's what the Court of Appeals said. They said it. Reading the contract as a whole, we find out that this is more or less a renewal option at the discretion of the tenant. This is not an automatic renewal clause. Even though it does state somewhere in the lease that the option will renew automatically, they said no, it was just an option at the discretion of the tenant, and this discretion is limited by the tenant's default, which took place. So the tenant cannot be in default right now because he had no right to ask for that renewal option. Maybe a better clause would have been that if the tenant is in default, then that gives the right to the landlord, at the landlord's option, to deny the tenant the right to renew the lease. So later on, the landlord could say, "I did not take advantage of my option. I could have denied you, but I didn't notify you of anything. So it should have renewed automatically." You see that? But when you make this statement, just a one solid statement, it could work against you. We've seen many situations where I don't have time in this video, maybe we cover it later on, but there was one case where the buyer had 10 days to do his due diligence, and if he notifies the seller of what's wrong with the property and the seller does not repair it within so much time, then the transaction was null and void. What the seller did, he had another buyer, so he decided not to do the repairs. And after the time expired, the buyer told the seller, "It's okay, don't worry about it. I still want the house. I'll take care of the problems myself." And the seller said, "No, you said if I don't repair it, then the deal is off. That's what you said." What the buyer should have said is, "If you don't repair it, then I have the option to choose to either repair it myself or to declare the contract null and void." You see how much difference this makes? And we can go on and on with different examples. I hope this works good for you and you can benefit from it in your practice, and I'll see you next time.